From the late 19th century, a very large proportion of the homes rented by ordinary people in England were social housing, provided by local councils. By the 1970s, this meant that councils owned a very large stock of housing, which required maintenance and which could not be rented out at commercial rates. Some councils sought to reduce this burden by selling the houses to their current tenants, often at below market rates. Mr. Gibson was a tenant in a council house, and the council had decided to reduce its stock of housing. He inquired about buying his house, and after an assessment, he received correspondence which said, "The council may be prepared to sell the house to you at the purchase price of £2,725 less 20% equals £2,180 freehold." It went on, "If you would like to make a formal application to buy your council house, please complete the enclosed application form and return it to me as soon as possible." Gibson should have snapped this bargain up. Instead, he wrote back with the completed application form but left the price blank and asked for a price reduction due to the poor condition of the front path. The council responded that this had been considered when arriving at the price. He responded, "Carry on with the purchase as per my application already in your possession." Before matters progressed, there was a council election, and the newly elected council decided not to proceed with any more sales unless there was already a binding contract. Was there a binding contract here? Gibson said yes, and the council said no. The matter became a test case before the House of Lords, where a majority said there was no contract. Lord Diplock quoted from the dissenting judgment of Lord Justice Geoffrey Lane in the court below, who had said, "There never was an offer by the council, acceptance of which by Mr. Gibson was capable in law of constituting a legally enforceable contract." Saying they may be prepared to sell was not an offer. Gibson's application with the blank price was not an offer. To be an offer, a communication must be capable of being binding immediately upon acceptance by the other party. And none of the correspondence here met that threshold. The judges were sympathetic to Mr. Gibson, but he lost his case and the chance to buy his house.